all here on behalf of the faculty for the inaugural lecture of Professor Mihail Danov. I'm very, very fond of inaugural lectures. It's a lovely occasion and a great opportunity to celebrate the huge store of experience and expertise and knowledge that our staff represents. So I'm going to be doing a bit of an introduction, a bit of biography, and once we've had the lecture, we won't do question and answer in the theatre. We'll be able to go and have a conversation over refreshments in the Queen's Cafe. So before we get to that, Richard is going to do a vote of thanks. So that's a bit of an outline of what to expect. First of all, then, for me, an introduction. So Mihail was born and grew up in what was then the People's Republic of Bulgaria. After completing his 18-month mandatory military service and obtaining the rank of junior sergeant, he went to study law in Sofia University. He then obtained an LLM in international commercial law from the University of Nottingham, and he duly qualified to practice law in Bulgaria. In 2005, Mihail was granted a full 6th century research scholarship from the College of Arts and Social Sciences at the University of Aberdeen. His PhD thesis, which was supervised by Professor Dr. Florian Becker, was completed in 2008, and a monograph based on this research, titled Jurisdiction and Judgments in Relation to EU Competition Law Claims, was published in 2010. Mihail started his first lectureship at Brunel University in January 2008. He was promoted to the post of senior lecturer in January 2012. And at Brunel, he also completed his first major research project, which was funded by the European Commission on cross-border EU competition law actions, which led to a major co-edited volume for the Hart Studies in Competition Law series in 2013. He then took up the post as Associate Professor at the University of Leeds. In Leeds, Mihail completed his second major research project, which was on cross-border litigation in Europe, which was again funded by the EU Civil Justice Programme and yielded a very significant, and I checked, it was 862 pages, published in 2017. It was a weighty tome. That year, in August, Mihail joined the University of Exeter. And since joining the law school here, he has continued to produce high-quality publications, as well as completing research projects on private antitrust enforcement and cross-border litigation in a Brexit context. A culmination of this work is his most recent monograph, published in 2023, Private International Law and Competition Litigation in a Global Context. Mihail is an internationally recognized scholar. He's the author of 30 peer-reviewed articles and chapters, with a solid track record in private international law and private antitrust litigation. He teaches on the LLB and at master's level. He's director of PGT for the school, and he's co-director of the Centre for European Legal Studies. I was going to say something about being academic conduct officer, but I didn't want to give you those tremors back. Mihail has been instrumental in opening up mooting opportunities for master's students. His contributions are many and varied to the school, and he's highly appreciated as a colleague. It's my pleasure now to pass over to him, to Professor Danov, for his lecture entitled Access to Justice in Cross-Border Private and/or Competition Law Disputes. Thank you.
Thanks very much. Thanks very much, first of all, for significantly expanding on what I've drafted as an introduction. So I appreciate it. Of course, I'll try to make a few corrections, because what we produced in the as part of this project on cross-border cross-border litigation in Europe, that's how it was called. It was an edit collection, so there were contributions for very many people. I contributed to 6 chapters, but yeah. Plus, I'm no longer the co-director of the Centre for European Legal Studies. It is Konstantinos now taking over the job. But apart from that, I really appreciate this nice introduction. I also appreciate the opportunity you give me to present and reflect on what I've been doing, and speak briefly about my plans, because and what I was, when I was asked or invited to do an inaugural, I was thinking, should I do it, should I not? I was, of course, assuming that everyone is doing so. I was thinking I'd rather not opt out of this opportunity. And then time passed and I started presenting, and because teaching starts and they say at some point you need to do it, and I was sent a reminder that it is due in January or February, and I hadn't started. And then I started recently reflecting, first of all, on what I'm doing, and I started thinking what I'm going to do or how I'm going to build on what I've already done. So that's what I'm trying to do as part of this lecture, and the title of, or the topic of the lecture is Access to Justice in Cross-Border Private and or Competition Disputes, and all my projects happen to be within this area, one or the other. So I have sort of two areas. One is private antitrust litigation, the other one is private international law. So what I'll be talking is pretty much the projects I've completed in these areas, and of course I'll be summarizing two projects which I plan to do and I'm currently working on, and I hope to continue to be working on those in the next 5 years or so. So when you have a couple of areas, then of course it was important for me to have a cross-cutting team, so to say, to link the projects together, to link the research together. So for me, this cross-cutting team is access to justice. Access to justice, and it is access to cross-border justice if it's private international law, or if it's a private antitrust litigation, you'll cover access to justice in the UK context. So what is peculiar for very many of these, especially competition litigation, but cross-border litigation on its own, that you end up having a lot of related claims, related proceedings. So then the administration of cross-border justice becomes a topic which is sort of intertwined with access to justice. And what is even more interesting, there are a number of legislative proposals at the level of the Hague of Private International Law Conference, or what is the European Commission Civil Justice Programme. And of course, there are a number of legislative proposals in the United Kingdom, which makes this areas highly topical, I should say. Of course, I'm biased. Just to get the idea, because many people may not be doing a lot of competition litigation these days. Of course, it's an area which is picking up at the moment in England. But when we're talking about antitrust damages claims, they would normally characterize as tortious claims. So this means that a claimant who is bringing a claim for damages would need to establish that there is a competition law infringement in the first place. So a competition law infringement, as part of this process, they'll consider the conduct and the effect of the conduct on prices, for example, or on process of competition, which may be link on prices, quality, and range of products. Yeah. So this competition law infringement sometimes may be established by a regulator, but sometimes there may not be a prior regulatory decision, and this may be a standalone action, but it always must be established that there is a regulatory infringement in the first place. So these cases, in addition to this, once they establish that there is a competition law infringement, they would normally bring a claim for damages. So normally they'll be claiming that this competition law infringement had an effect on the prices in the United Kingdom, say there was an overcharge of 25%, which means there is a price uplift of 25%. So if it's trucks cartel, the price of a truck would be, say, 50,000. The cartel uplift would be 10,000, so it will be a high-value dispute. Yeah. So the other specific thing for this type of disputes is that when they start bringing a claim against the defendants, the high value of the claims would mean the defendants probably would be quite willing to fight. They won't pay a few billions just out of courtesy. So what the claimants would normally say, well, if there was a competition law infringement, first, it didn't have any effect on the prices in the UK. Yeah? Second, even if it were to have effect on the prices in the UK, you passed on the overcharge down to the chain of commerce. So that tried to make it difficult. So what is an added layer of complexity? That these infringements would cause harm to multiple injured parties. So there will be an issue about dealing with related claims in the UK, and there will be a closely intertwined issue about governance of related claims in other jurisdictions. And there will be other jurisdictions, because if you're talking about Google, Apple, they'll be facing multiple claims across the globe. So it is high value, high stakes litigation. So just to show that I'm not making up those problems, I've taken a quote from a recent judgment. You see, from the case is still pending before the Competition Appeal Tribunal. So what they're saying, it is not only that there are very many claims brought in the United Kingdom, but there are thousands of claims against the same infringing companies brought in other jurisdictions. So as you can imagine, this increases the defendant's exposure to damages, raising the stakes for them and delaying settlements. And they wouldn't be unwilling to settle, because for this particular case, so only the UK claim where the quote was taken from is for well over 3 billion. So this is only one jurisdiction where the cartel agreement was implemented. So there are multiple proceedings across the European Union. So what they did, they didn't settle any claim before the limitation period expired. Because if they were to settle, this would invite other claims. So they'll delay and prolong. So this would inflate the costs. Yeah. So what are the major challenges now? So I hope you understand now what are the problems. So just to set out the major challenges. We're talking about transnational economic activities. And we're talking about multinational groups of companies. And I've named MasterCard, Apple, Google, Amazon, Meta, but most of them would be. Because they will need to have significant market power to be able to raise prices above competitive level. So we're talking also about transnational infringements, because all these companies are not only active in the United Kingdom, they're active across the European Union, across the globe. So, and what is more, we're talking about long-lasting infringements. So this means causing harm to millions of consumers and businesses, aggregate damages in the billions, and there was a recent decision of the Competition Appeal Tribunal in Kent and Apple awarding approximately 1.5 billion to the UK consumers. So these are real issues. So enforcement, because of the nature of the infringements, you can imagine there is need to have public enforcement to safeguard the interests of the consumers. Digital markets increasingly regulated, so you have public enforcement regulators and you have private litigation, which is normally paid by private. So what we have in England, we have hedge funds investing in private litigation. So highly interesting. So administration of cross-border justice is important because we're talking about different regulatory regimes. This means they may be legitimately pursue different objectives. There may be a conflict of competition laws, a conflict of competition law objectives. In addition to this, there are bound to be related proceedings, which raises the risk of irreconcilable national decisions in relation to the same economic activities. So, the higher the level of uncertainty, the higher the stakes for defendants, given their exposure to damages, given the fact that their business model may be regarded as anti-competitive. The higher the enforcement, the higher the litigation costs, and plenty of literature on that one. So there are real issues concerning access to cross-border justice, and there are issues in the developed countries, but you can imagine that all these issues will multiply in the developing countries because they wouldn't probably be able to prove that there is an infringement committed by Google or Apple or these highly sophisticated companies. So, access to cross-border justice is a cross-cutting theme on which I want to continue working. So litigants in dispute with international element would have to take cross-border litigation risks. There will be higher litigation costs, level of uncertainty concerning jurisdiction, applicable law, because there may be multiple applicable laws in these cases, and multiplicity of related and parallel proceedings. In addition to this, the high costs and the high level of uncertainty about the outcome, because very many of these cases against Google, they are novel type of infringements, or Apple. So this means that there is inevitably a high level of uncertainty about the outcome. This could adversely affect claimants' litigiousness, risk benefits, inflate the litigation costs, and there may be real issues for consumers and SMEs' access to justice. So, the litigation funding is the UK solution, which I understand is a solution which is, of course, advanced in very many other jurisdictions, which aims to improve injured parties' access to justice. But it only works if the value of the claim is sufficiently high. So you probably need a procedural mechanism which enables the value to be sufficiently high. Otherwise, they wouldn't be investing in those proceedings because the cost may be 20, 40 million, and then you have the loser pays rule, so you have to cover the costs of the defendant. As Christine Riffer knows, if you lose the case, you need to pay the costs of the defendants. Yeah. So, now I need to reflect a little bit and then I'll summarize briefly what my research plans are. So as you see, it's a very interesting area. It has always been a very interesting area, which is why we enjoy doing research and talking about research when people are marking. So, following my PhD completion, so I published my first monograph, what Adam kindly said, but it is really important to acknowledge the people who supported me with this project. It was a risky project. And completing in 2008 reminds me that I've been working in this area more than 20 years, which I had no idea that I've spent so much time working in this area. At the time, it was a very interesting topic for me. I picked up the topic when I was doing my master's degree in Nottingham. And at this point of time, there was a white paper which was supposed to promote private enforcement. And in order to attain or have this private enforcement working, they said we're going to rely on the Brussels I regulation, which allocates jurisdiction within the European Union, without realizing that the Brussels I regulation was not suited to deal with this type of disputes. So I started doing this, but of course, very many experienced academics would say, well, this is very interesting, but I'm not sure whether there is enough for you to write a PhD thesis on that. One thing for sure, now you have enough, but at the time there was not enough because there were very few cases, if any. So the first person who trusted me that I can do that was Professor Tibor Varadi from, he's from Serbia, I believe. but at the time he was based at the Central European University. And I believe he was also a professor at Emory University of the United States. So he was quite a good scholar. He was the first Central and Eastern European person to graduate or get a PhD from Harvard. So he was a celebrity in our part of the world. And he still is very good academic. So he said, I think you can do that. And helped me refine that. And it was 2005, actually. I got a scholarship. I got a scholarship to do this project in Aberdeen. And my supervisor there was Professor Florian Becker, who helped me a great deal. And he encouraged me actually to submit well before the deadline. I was saying, but it can get better. He says, listen, it always can get better, but I think you're ready to go. So I trusted him on that one, and I submitted, probably 1 year earlier. So at the Viva, I met my PhD examiners, and one of them was, of course, Professor Paul Beaumont. And the other one was the late Professor Jonathan Fitchen. And I had a good Viva. And actually, this conversation with them set the scene for first to improve or to convert my PhD into a monograph. So it's a revised version of the thesis, but it's significantly revised, probably 50,000 words were added. But it also set the scene for my future projects. So I would say, so it was a sort of a groundbreaking analysis, how the post-2003 EU framework for decentralized enforcement, what they call modernized regulation, would work under what was the relevant, considering what was the relevant private international law regime. So it helped me a great deal first to pass my probation at Brunel, publish few research outputs. So I met my probation targets, but one of my probation targets was to submit the funding application. They didn't say where, just submit the funding application. So at this point of time, I saw a call by the EU Civil Justice Program. And you said in order to apply for this, you need to have partners from 2 member states. And I didn't know anyone from another member state, but my supervisor, Professor Florian Becker, just got a job at the Q University in Germany. So I'm saying, listen, there is a call. Should we bid on that? He says yes. And I did the proposal, I submitted the proposal, and then I ticked my submission box. I was thinking I'm done, and a few months later they're saying, well, you got funded. And at this point of time was kind of shocking thing because it was a big project. I was the PI, but we promised the world. We promised we're going to do interviews with practitioners in London, and some of my peers at the time saying, but what if no one wants to speak with you? So, but then we had funding. And then I met a very important person on this occasion. So we had the funding, as I said, decent amount of funding at the time. It was a relatively big project. So I had to organize my first workshop, so I canceled my holidays and started organizing workshop because I know that I need to invite legal practitioners. And I'm sending invites, and normally no one gets back to me. As at some point I get an email back from John Lawrence he was leading the litigation department at Freshfields. It's a big firm. So he comes back and he says, can I have a chat with you? So sort of interview. And I say, well, okay. And we had the chat, and he said, I'll come up. I'll take part in this. And then he came in November, and we invited other, because he was quite a name, so we started inviting a lot of people around him. He probably knew that when he said he was going to take part. So we had a good workshop then. He spent the whole day actually at the time and was talking to us about competition litigation. It was a big thing because all the big cases at the time about private antitrust enforcement and private international law were dealt by Freshfields. So it helped me big time. So then we involved a lot of people. We involved very, very good practitioners. He wrote a chapter for us, writing about litigation tactics. Then we organized a conference, and we had a few hiccups here and there. I wanted to transfer the project to Aberdeen, and we spectacularly failed to transfer the project to Aberdeen, and then I had to come back to Brunel. But apart from that, academically, everything, apart from the administrative stuff, everything went smoothly. We had the final conference at the LSE. We had very good turnaround, and we published, I would say, a very good book. As I say, it is edited collection, but I probably contributed to most of the chapters, well, the majority of the chapters, but we had very good set of practitioners and academics from around Europe. So the purpose of the project was to, as I said, to identify how cross-border EU competition law actions were to be accommodated in the European Union. And this went very well, as I say. And because it went very well, so we published this with, so we see, I co-edited this along with Professor Dr. Becker, who was my supervisor, and Professor Paul Beaumont, who was my internal examiner. So then, because they were quite happy with what we did, so Professor Paul Beaumont invited me to take part of this Jean Monnet project. So we set up an EU research network. So the idea here was for us to expand our hypothesis and cover not only cross-border EU competition law actions, but cover all cross-border litigation in Europe. So in order to set the scene for this project, of course, we started inviting people. So you see Belgium, Croatia, Italy, Spain, Sweden, and Turkey. So we got some funding. We organized 4 workshops at Aberdeen, and we organized 3 workshops at Brunel. So at Brunel, I remember we had Belgium, Sweden, Italy, and Spain. So it was very interesting from my perspective because we got really good jurisdictions. And then this led, so we refined the hypothesis, we refined the framework, and then this led to another project. We call it the EU Pillar Project, but it was concerning how the private international law framework was functioning in the European Union. So we pretty much built on this project. We attracted good litigation. Well, we attracted a lot of funding at the time. Was a relatively, I had a decent buyout, probably had 40%, which was good for me to do some research. And what Adam said, we produced a massive volume involving contributions for very many people. I contributed to 6 chapters, but my contribution pretty much was to set up a theoretical framework and framework for collecting data and do the comparisons in a cross-border context. So the idea was for us to identify the factors which impeded the parties' access to justice in cross-border claims. And it was a significantly bigger project in comparison to cross-border EU competition law actions. And I mentioned this LSE conference and the Brexit referendum because this happened. The LSE conference took place on 16th and 17th of June. And the Brexit referendum vote was on 23rd of June. And on 16th of June, people probably don't remember, but 16th of June, the Labour MP, Joe Cox, got killed in, near Leeds. It was kind of big thing because we spent all day discussing cross-border litigation, discussing our next project, because once you identify the factors which impede private parties' access to justice, then the next project was going to be about how you improve their access to justice. And we were planning this project, and I remember we had the keynote speaker, and he's coming, Lord Justice Voss. And I spent all day talking about competition litigation. I had to meet him and go together to Lincoln's Inn. And we were walking together, and then he told me about Joe Cox. Apparently it was all over the news all day, but I had skipped the news. And then the next week was the Brexit referendum, which meant what? That we never submitted this bit about improving access to justice. So it was a turning point pretty much for me, because at this point of time we had to reflect, set back, and probably try to change the research agenda pretty much, because that's what we did. So at this point of time, we decided to do a pilot study, which I did, and the law school helped me with that. So the purpose pretty much was, because it was a very tricky period, because there was a Brexit vote to leave the European Union, but Brexit hadn't materialized. So it was a very tricky period to do anything about assessing Brexit impact, because there was no Brexit impact whatsoever. So it was pretty much to gather some empirical data, just to see how the legal and political uncertainty at the time and all speculation impacted on cross-border litigant strategies post-Brexit vote, but before Brexit actually materialized. And then the whole idea was to refine a socio-legal model to measure the impact of Brexit on the parties' access to justice in cross-border cases when the Brexit were to materialize. So pretty much the idea was to set the scene for a post-Brexit empirical study. Yeah. So I got away, I published some good papers out of it. We got an HSC-funded research network. Very many people supported us. We got judges, practitioners. We had very many people involved with that. As I say, published a couple of papers. 3 papers probably managed to publish out of it. It was pretty obvious at this point of time, or it's getting pretty obvious at this point of time, that the European Union would be reluctant to allow the UK to remain part of the Lugano Convention. And that's what happened later on. So this was all good, but there are some important post-Brexit developments on which I want to, now I'm starting talking about what we want to do, building on what we've done. So now, what we want to do. So, of course, post-Brexit, this was a massive change to the legal landscape. The UK has already changed it a little bit. It has become part of the Hague Convention for Choice of Court Agreements. It has recently ratified the Hague Convention on the recognition and enforcement of foreign judgments in civil and commercial matters, and this entered into force on 1st of July. So it's relatively recent development. The only remaining gap is in relation to parallel and related proceedings. And that's where we want to work on. And of course, there is a proposal from the Hague on that one. So that's pretty much where we want to work. So just to give you a hint about the post-Brexit developments, because we were expecting at the time, and when we were doing it, the Brexit would probably have impact only on the one side. But apparently Brexit has impact on both sides, which was not difficult to imagine. And so a lot of it is happening right now. And some of you might remember last year we had Karen from the European Commission, and she was actually leading the competition, the civil justice team, who drafted the Brussels 1 regulation, Brussels 1A regulation. So in June 2025, the European Commission formally initiated a review of the Brussels 1 framework. We still have time, yeah? Interestingly, they want to review the notion of court or tribunal, which is pretty much what I was claiming they should review. They want to review the effectiveness of the provisions on jurisdiction, and in particular Articles 7.1 and 7.2, as well as those related to consumer contracts, and none of them were suited for competition cases, but apparently they are now wanting to review those. And the other thing which they want to review is the collective redress, which is pretty poor, so it is a good spot to review. So that's what happened in the European Union. And you see, there are also developments in the Hague. In the autumn, and that's something which I've been following very closely, because Professor Beaumont is part of the working group, so I've been following the work of this proposal. But they tabled now the draft text of a future convention on parallel proceedings and related actions. So this, what I said, was probably the missing piece in the Brexit landscape in relation to private international law. What is more, in December 2025, they initiated a public consultation. So we are pretty much waiting to see what they're going to decide come March, because that's when they're going to take the decision whether they will continue to work on that. And we hope they will, but that's pretty much, we want to focus on set up a project which is going to build on what we've covered, but focus on these particular issues concerning access to justice in parallel and related proceedings. As I say, the topic requires renewed attention post-Brexit, but in light of the Hague proposal. We can draw, so we're probably well placed to do it. We can draw on our prior HRC funding network and the EU Pure project, which is capturing, without intending, we're capturing exactly what was happening prior to Brexit. So we have one which is an interim pilot study. So if we manage to do a post-Brexit study concerning access to justice, we'll complete the set. So, Isabel is timing her on because I mentioned her name. So, to take the most of this opportunity, we've recently set up a cross-border litigation research group, and hopefully we'll try to, this is an area where we want to continue to work. As part, I would say, as part of a collaborative team, and there is plenty of room to collaborate in this one, which is why I'm using this opportunity to invite people who want to be part of it. So, but there is plenty of room to collaborate because there are regulatory issues. Competition is the most obvious, but you can talk about data protection, financial regulation, environmental law and policy, private law issues, contractual issues, tort issues about fraud, breach of statutory duty, causation, quantification of damages, company law issues, because most of these guys will be big multinational companies. So, as I say, environmental law disputes, human rights dispute increasingly you have, especially coming over to litigate in England and relying, of course, on the litigation funding. So that's one project, private international law. Of course, I have another project on private international law. What you see, in addition to private international law, I continued working on the developments concerning antitrust litigation. There is even bigger gap there because there is no regime for judicial cooperation in antitrust and competition matters, too sensitive for any country to agree upon this. So these matters are normally excluded from the scope of the Hague Conventions. Again, I did a pilot study in 2022, because you can see post-2020, there was a decision of the UK Supreme Court which said that collective claims shouldn't be reviewed on the merits, so there wouldn't be a merits threshold. Post-2020, there was a rise in class actions. So at this point of time, 2021, I was thinking we need to do a pilot study. And again, I got very good support from, I should mention it again, John Lawrence, who is now Brickcoat Chambers, of course, Freshfields. They have consistently helping me. Nicholas Frey, who is the head of the competition litigation group, and he's teaching with us. He's honorary associate professor here. And Omar Shah from Morgan Lewis. So they've been helping me, of course, Professor Barry Roger from Strathclyde. So they've been helping me to devise sort of an advisory board to set up the theoretical framework. So the purpose pretty much was to identify the difficulties in relation to quantification of damages, identify the problems with regard to case managing related claims in the United Kingdom, which both cumulatively delayed settlements and inflated the litigation costs. What was obvious at this point of time, that the UK Supreme Court decision in merits and the litigation funding both had a significant twist in the litigation pattern in the United Kingdom. There were significantly more standalone claims. There is no regulatory infringement, so there are standalone claims and claims regarding abuse of dominant positions. And very many of those will be brought against the big tech companies. And very many of these big tech companies will be facing related proceedings in other jurisdictions, which meant that this case is very costly and difficult to settle. So I produced a number of outputs here. First, along with Carmen Otero from Madrid, we considered the limitations of the 2019 Hague Projects Convention. Then I produced a research monograph, which Adam mentioned. Again, data collection, a paper regarding the data we gathered and considered how the effectiveness and efficiency of the current enforcement pattern should be enhanced with the view to improving injured parties' access to justice. So pretty much evaluated how the current regime was functioning and set up certain proposals which should hopefully improve injured parties' access to justice. So two things should I mention. I should mention that my monograph addressed the complex private international law issues that arise in cross-border private antitrust damages claims. But given the fact that it's very difficult to agree to have a convention or any form of formal cooperation, judicial cooperation, I came up with an argument for a new approach to governance, so to say soft judicial cooperation using the law firms, which is probably, well, it's certainly what is happening. And it is something which is continue to be happening. So what is increasingly happening, say, regulatory proceedings in the European Union, this informs claimants' pleadings in the United Kingdom. And decision of the UK Competition Appeal Tribunal saying Apple business model is anti-competitive, I'm pretty sure this would have impact on the proceedings in other jurisdictions. So it's a soft type of cooperation. What is the other thing which I did, and because normally when you're doing this type of big projects, you normally need to come up with a solution. So in order to come up with a solution to the problems we identified, and of course, hopefully I'm hoping to sell this solution to the European Union in order to bid for funding there. But in order to do this, of course, I did a small paper which concerned the transnational nature of the Competition Appeal Tribunal. It's a unique tribunal because the proceedings of the Competition Appeal Tribunal may be treated. So it's a UK appeal tribunal, it's a UK Competition Appeal Tribunal, which means that it is not English, not Scottish, not Northern Irish. When I say this to students, they laugh. But in fact, and I'll tell you, it's becoming a big issue. So the proceedings may be treated as taking place in Scotland or England and Wales, and if they're treated, of course, there will be different rules with regard to procedure, with regard to costs. The applicable law may be slightly different. So we made an argument that these issues should be more systematically dealt with. But what is even more interesting, there is a competition litigator, Katriana Monroe, who is now bidding, or she's want to participate in the Scottish elections to become an MP in Scotland. And she wants to make Scotland antitrust haven, which is an entirely new development. Someone told this to me yesterday, and we're about to organize a small workshop. So we're thinking to invite her. And the workshop which I'm talking about and inviting people from Scotland is because there are recent developments in the UK. The UK is now trying to revise, or so to say, review how the opt-out collective redress regime is functioning. They tabled the call for evidence, but if you read the call for evidence, a statutory intervention is highly likely. There are some massive judgment, as I mentioned, Kent and Apple awarding significant amount of money, more than 1 billion, to claimants, UK consumers. There is a statement of the Minister of State for Justice saying that litigation funding sector, or there'll be legislation to continue to support litigation funders, to support and invest in litigation. And there is a massive decision in the UK Supreme Court, Evans and Barclays, which says now that they're raising the threshold for certification of collective claims, indicating the strength of the claim now would be scrutinized. So this would make it slightly different, more difficult to certify those. But we're hoping that if they scrutinize those, it might be easier to settle, because if it is a weak claim is certified, it may be very difficult to settle. But if it's properly scrutinized at certification stage, this may, especially if they scrutinize the strength of the claim, this may encourage settlements. So what is interesting, our study actually, what we did as a pilot study, happens to be the only study which looked at these issues prior to the call for evidence and after the 2015 report, after the 2015 Consumer Protection Act, which set up adopted the opt-out collective redress regime. So pretty much saying that a claim may be brought by class representative on behalf of millions of UK consumers. And you can see it is pretty much detecting what we've detected, that there is a significant rise in collective claims. Pretty much in England, no one waits anymore for regulatory proceedings. They simply see the Commission is investigating it. It gives them a theory of harm. They involve economists and they make a case which has reasonable prospects of success. They get funding. So what we're trying to do with this cross-border litigation research group is we recently established this. The idea is to connect legal practitioners and collaborate on research projects which improve access to justice. We applied for internal funding. We didn't get it, but luckily our partners from Freshfield said we're going to cover the cost. Well, they don't want to cover the whole cost, but they'll host an event there. So the idea is to invite practitioners, hopefully invite people from Scotland, connect with other academics and bid for European Research Council funding. This is an ongoing project. We tried 2024. We got to B, but we are working to raise it to an A. So the purpose pretty much is to ascertain how related claims will be dealt in the same jurisdiction and go a step further and see how related claims will be dealt in different jurisdictions. So we bid for this one. We're building on a prior bid. And I'm saying a distinguished research team, but this is what came from the peer reviewers. So I'm not making it up. They said they have a distinguished research team. So I'm supported in this, so I'm not working on my own on this project. So I have Dr. Matthew Cole, Dr. Isabel Rueda, Professor Chongo Istvan-Nagy, Professor Marta Petragas, and Sergo Harder. Of course, we expanded now the team. We have Professor Mihail Ferro from Lisbon University and Dr. Julia Sudorov from Spain. So we're expanding this and we're hoping to bid for funding. I'm using again this to promote and anyone who wants to join us, please let us know. But the idea is to use this cross-border litigation research group to involve colleagues from the law school, from other departments, involve various stakeholders with the view to setting the scene for business engagement and innovation activities. Ultimately bidding from, ECSC, large center funding, maybe a long-term aspiration. I'm not saying we should anytime soon, but long-term aspiration. Nothing wrong with having ambitious aspirations. So, to summarize, research is fundamental for what we do and what I do. It is really important for me. And in terms of improving my knowledge, understanding, ensuring that we maintain the high academic standards whilst further enhancing the reputation of our taught programs, try to continue to contribute to the school strategy and continue delivering excellent research-led teaching, which you reminded me that I need to mention, with the view to supporting students' learning, to develop their analytical skills, which should hopefully help them enhance their employability. So I use this just to summarize, as I say, what I've done and hopefully what I plan to do. And plans are constantly changing, but at least that's what I'm hoping to do.
Thank you, Mihail. That was a fascinating lecture. You showed us how your career trajectory has mapped some of the major events that's happened in the context of cross-border private law, justice and redress. You are a truly global scholar. We can see all of the esteemed colleagues that you're working with right across the globe, particularly Europe, which is fantastic to see. You have a strong track record of funded and impactful work. But just as important as all of those things, you're also a wonderful colleague. And we wanted to say that we really value your contributions across all of our portfolios: education, research, leadership, noting in particular for the last couple of years that you've led on our PGT portfolios, which is no easy task. So thank you so much for your hard work. Thank you, everyone here, for coming to the lecture today. And do please join us for a drinks reception, which is inside this building, so do follow us as we go. So before we do that, allow me to congratulate Mihail once more for his professorship, which is a fitting recognition of his outstanding contribution to the field. Congratulations, Mihail.
Thank you. Thank you.